I'm Prophet Ron Dwayne Whitfield, recording on Tuesday, 26 January 2021.
November 13th, 2020, 2:14 p.m., 21 hours ago. All. From Last Prophet Ronald Dwayne Whitfield andikomonilavim@gmail.com. Date, Sunday, December 13th, 2020, 5:34 a.m. Subject, United States Supreme Court, Original Suit, Number 220155, Texas vs. Pennsylvania, et al., and United States Court of Appeals for the Fifth Circuit Docket Number 19 to 20292, Whitfield vs. Texas Memorial Hermann Hospital, for Chief Justice to take corrective action against respondents, circuit judges, willful interference with and obstruction of the appellate jurisdiction, and of the administrative duties of the Chief Justice of the United States Supreme Court, respecting the litigants' right to motion the Chief Justice to order appeals be forwarded up and reassigned to another Federal Circuit Court of Appeals for disposition. To Clerk of Supreme Court of the United States. Brandy Brenna Whitfield, acting on her own behalf, individually, and Prophet Ronald Dwayne Whitfield, acting on his own behalf, individually, and both jointly, providing notice to all the justices of the United States Supreme Court, and presenting their motion, and thus making demands for corrective action on their joint motion to transfer appellants' direct appeals to Chief Justice Roberts, and to Circuit Justice Samuel Alito, assigned to U.S. Court of Appeals, ordering the judges of the United States Court of Appeals for the Fifth Circuit to cease stonewalling on their motions, and appeals to be transferred to this court, and then assigned to another Federal Circuit Court of Appeals by the Chief Justice. Dear Mr. Chief Justice Roberts and Mr. Associate Circuit Justice Samuel Alito, USCA, 5th Circuit. May it please all the members of the court, we are some of the real parties in the Texas case referenced above. See FISA court opinion cited below. Now comes Mother, Brandy Brenna Whitfield, in propria persona, acting on her own behalf, and now comes Prophet Ronald Dwayne Whitfield, in propria persona, acting on his own behalf, and together, both jointly and singly, would respectfully show as follows. 1. Filed on January 25, 2017. Docket number miscellaneous .13-08. United States Foreign Intelligence Surveillance Court, Washington, D.C. The last shall be first and the first shall be last. With respect to this term used by the United States Foreign Intelligence Surveillance Court, and this United States Supreme Court, cognizable interest. Be it resolved that, as explained in parts 1 and 2 of the following discussion, this court has jurisdiction over the motion of Texas to file a bill of complaint only if it, the motion, presents an actual case or a controversy under Article 3 of the Constitution, which, in turn, requires, among other things, that the movants assert an injury to a legally protected interest. Because we have and because the court's order of denial includes no decretal language of ordering that the case be dismissed, and thus removed from the docket, and put out the court, it pens. Indeed, we observe that the FISA court in its opinion used similar language there as used by this court in her order denying our motion to file bill of complaint in this court. The FISA court, in said opinion, aware of the need for a correct disposition, stated that that case would be dismissed by a separate order, and that separate order actually ordered the case dismissed. Therefore, no motion to reinstate is actually needed here, since a case pens until there is an actual disposition. Make no mistake, accordingly, the state of Texas, accordingly, to support our position that our Texas Attorney General's motion to file a bill of complaint satisfied, and still satisfies the cognizable interest component of standing, that is, we citizens of Texas having suffered such an invasion of a legally protected interest, and therefore having indeed established a colorable claim to a right that is legally protected or cognizable for the purpose of establishing an injury in fact that satisfies Article 3 standing requirement, here we adopt both it Our response to respondent states response ordered by this court, and the opinion of the FISA court referenced above, and we incorporate same herein fully, together with the legal authorities on which they recite and rely. Make no mistake, to say that the federal constitution confers a right on each legislature of a state to choose, per candidates for federal office, that is, for both senators and representatives, is to say just one thing, which almost has nothing to do with we citizens of and we citizens who reside in the state of Texas, since those senators and representatives' authority to act on behalf of their own district's constituents do not affect we citizens of Texas. However, the same is not true when, and where the President and the Vice President of the United States are on the ballot in the state or Commonwealth of Pennsylvania, and any other states. Why? Because their authority and acts taken pursuant thereto are not just limited to the state of which they are empowered to act. Rather, their affected acts here have affected the whole nation, and as stated in our pleadings, in an adverse and non-constitutional way. And while it is true that the federal constitution gives all legislatures in the several states the right to conduct their elections in a manner being authorized by the laws of the states, but what still comes with that right is also the duty to comply with the election laws of each state, especially when the president is on the ballot. This we call the rule of law. As most all people already know, in the United States, and in each state therein, while any free person, and of legal age has a fundamental or God-given right to smoke cigarettes and drink alcohol, that right also creates and imposes a duty on such a person to act within the confines of that right. For example, smoking cigarettes causes many health problems, and it leads also to death. So, the same body of laws that recognizes such a right to smoke and drink also imposes on such person limits on where, and when the person may enjoy such right, and such duty is to protect others who do not exercise the same rights, choosing or electing to live healthy. See Steel Company vs. Citizens for a Better Environment, 118 S. CT 1003, 1998. To the extent that this court's order implies that the minority and the majority of the citizens who voted and did not vote in this 2020 presidential election in these battleground states declined to sue their elected officials for violating their constitution and election laws of their state in this national election, we agree with this court that we have not demonstrated any judicially cognizable interest here, as the court correctly concluded, just as long as those said violations affect only, for example, the smokers, drinkers, and voters of those states. But we may not agree with this court's conclusion that these violations, example, air pollution from cigarette smoke, and those citizens' conduct tea in drinking alcohol, and then traveling into our state causing wrecks and our citizens to be killed in motor accidents in Texas, lend to us no legal standing to both bring and maintain this action here. We cannot allow this. B. It is one thing to have the right to act reckless and catch, for example, the coronavirus from another person, and so forth. But there is no right to have acquired it, and then recklessly spread it to another, and certainly not to we Texans. Likewise, where a state makes her laws and violates them in her own state, and local elections, that conduct affects only the people of that state. Other people in other states have no legal standing to complain. But when and since these defendant states violated their own laws in this presidential election, that conduct illegally injured we Texan. To be sure, if those states' electoral votes were to be set aside, or if we assume such states did not exist at all, obviously, no candidate would have obtained the 270 such needed electoral votes. But for their conduct have we been said to have lost in this national election in the choosing of our presidential candidate. 2. In Texas, some statutes confer a right on a litigant to enjoy counsel in a suit affecting the parent-child relationship. However, the law does not impose a duty on a litigant to accept such right. As this court has also similarly held elsewhere, while no state prisoner has a right constitutionally protected to be physically freed by the state from imprisonment through parole, however, this court has ruled that, if a state elects to create such a right to be physically freed from imprisonment on parole, and recognizes that a violation of the terms and conditions of release may result in a revocation sanctions of that conditional release, such prisoner has a sufficient liberty interest. that such due process constitutionally demands that liberty interest be protected by the 14th Amendment, that is, to not have parole revoked in absence of the protections afforded by due process. Here too, when the violations of the election laws and constitution of another state, in a national election affects the outcome of the entire nation, as a result of those violations, the entire nation clearly has Article 3 standing here to sue under Article 3 of the Federal Constitution. Some people have a right to vote, and yet they have no duty to vote. We Texan have no duty to accept our votes watered down by the unlawful violations here of which we have complained. 3. Accordingly, therefore, both jointly and singly have we submitted to the clerk of this court, and in his official capacity, do we move that he present to each of you this instrument for both immediate and corrective action. To expedite our issues and demands herein, we adopt by reference and incorporate the opinions filed in Steel Company v. Citizens for a Better Environment, 118 S. CT 1003, 1998, and Texas Association of Business v. Texas Air Control BD, 852 SW2D 440, Texas 1993, as each relates to jurisdiction and her component standing to bring and maintain this suit. In the lawsuit filed by Texas against Pennsylvania, ETAL, given that we are inhabitants of the state of Texas and citizens of the United States, the Attorney General of Texas was legally authorized by both Article 3 of the original Constitution for the government of the United States of America, and by Title 28 U.S.C. subsections 1251, A and B3, to bring this actual case or controversy into this court for resolution and a satisfactory remedy. The order of this court specifically states that this motion seeking leave to file the bill of complaint is denied, but does not, however, go further to declare that the case itself is dismissed with prejudice. See decretal language, last words of an appellate opinion, by Honorable John O. Newman, as a matter of law, which law is none other than the supreme law of the land, which is Article 6, Clause 2, of the original Constitution for the government of the United States of America. As such, the case created by the motion is still pending in this court, albeit the relief it seeks has been ordered denied. Evidently, under this court's original, constitutional, as opposed to her appellate, jurisdiction, not only has the court no discretion to grant or to not grant the motion itself to bring this controversy into the court, but rather, the court has a judicial duty to grant the motion for leave to file the bill of complaint, and then after, if standing be satisfied after the motion for permission, or leave to file the bill of complaint has been granted because that granting of the motion, not its denial, is what creates an actual case, and or an actual controversy, resulting in the court entertaining and exercising her original judicial powers, but also the court must hear the merits, unless standing then be not established. Again, the motion itself must be granted under Article 3, and subsections 1251, supra, because the court may not obtain only drive-by jurisdiction to hear the motion, but somehow it loses jurisdiction short of determining subject matter jurisdiction to hear the bill of complaint itself on the merits the actual case or controversy again, on its merits. In other words, the legal result must be the same, for what jurisdiction can no do directly, it then cannot do the same thing indirectly. More specifically, the motion for leave to file a bill of complaint is an action separate from the bill of complaint itself. What the court has to do to hear the case brought by the bill of complaint is simply order the motion for permission to file the separate bill of complaint. By doing so, the court has both jurisdiction, power, and, you justices obtain then, authority, to act for the court herself, and therefore the right, to consider the dispute brought by not the motion or request for leave to file, but brought by the attached and filed bill of complaint. This court cannot acquire power to hear and give opinion about a matter that has not been allowed be filed and docketed in this court. Just because a court must grant a motion to reinstate or to reopen a case to acquire jurisdiction to hear the motion that act does not mean that the court must also grant the relief for which is being sought under the motion. It is mere a prerequisite, just as is the President oath of office. Before the President may enter on the execution of the sacred office of the President, Biden must take an oath of office. Taking the oath does not render Biden President. MOING on in a Texas case brought in the Supreme Court of Texas. The action of this court is much like therein where the Texas Supreme Court found that it would be impossible for the trial court to have denied a motion to reinstate a case, incorrectly dismissed by the clerk of the court, when that same motion had not yet been filed at the time the case was dismissed. Here clearly, this court has assumed that the state of Texas could neither in her own right nor acting on behalf of her inhabitants properly invoked the judicial power of this court, because, evidently, a majority of the members of this court, after reading our motion for leave to file our separate bill of complaint, which, of course, was not allowed be filed as of yet, because the motion was denied, the majority was somehow able to conclude that our bill of complaint itself, which then could only be attached to and marked only as received, and not marked as yet filed, nevertheless also would not demonstrate to the satisfaction of the majority the requisite showing of our standing to bring and maintain our suit. The judicial power conferred on this court under Article 3, like under Title 28 U.S.C. subsections 1251, A, B, 3, is a grant of this court's original, constitutional jurisdiction by the United States Constitution itself, and, by Congress, it is regulated to this court by that act. Just as much as the Constitution confers such legislative powers the states in the election clause pertaining to the legislatures of the several states, reserving to Congress the right to modify or alter the acts of the states thereby. The judicial powers here, of course, shall extend to controversies between two states or more than two states. That is the state's right to sue out in this court another state or more states in disputes between and among them, which disputes themselves constitute the actual controversy. Neither the Constitution herself nor any federal law expresses in particular of what the subject matter may be about in the controversy, not water, but a national election in dispute, such that a state may bring into this court to entertain and resolve. As such, whatever the controversy may be about between the states, which is in dispute, here, the results of a national election, standing to sue is granted by the Constitution, and the laws of Congress regulate the exercise of this court's original judicial powers, and so this court exceeds its judicial powers in imposing on the states its rule of law of standing that the court itself judicially created. It is not the role of the court to create law, but is to apply the law, as is already written in the Constitution, or by the lawmakers, to the case in controversy. As it stands, the court has acted and can always act capriciously and arbitrarily because, if it is up to the court, and not set by the law, the court can always simply render a conclusion, never to be explained, to the public the legal reason that it 1. Feels, 2. Thinks, 3. Believes, 4. Knows, or 5. All 5. That we have not demonstrated a judicially cognizable interest in the manner in which other states conduct their election. Why the majority says this we are not told. Yet we all know from our school education that to be convincing when you write and when you speak, even the members of the Supreme Court of the United States need to back up their opinions with reasons and evidence. Nobody, at least in today's world here in the year 2020, is going to believe that what you say is true just because you say it. You need to build a sound, logical argument consisting of your opinion, reasons, and evidence that we have not demonstrated, even if Article 3 specifically had required it, the standing to sue component judicially created. Evidence is any kind of specific information that the court can use to back up its position. Evidence may consist of facts, statistics, examples, quotation from experts, and incidents. V. Just like Judge Marvin O. Teague held, like the opinion opens in Texas Association of Business versus Texas Air Control Board, 852 S.W.2D 440, Texas 1993. Here, 2T, he, State of Texas, on behalf of itself and her citizenry, brought this bill of complaint, action seeking rulings that statutes empowering such state legislatures relating to the 2020 federal election violated both substantive and procedural due process of law, and the equal protection of the law, how unconstitutionally, by delegating such powers to their administrative agencies, and those agencies, in turn, willfully violated laws in each said states, which regulate provisions of state laws as relating to federal elections, because the actions taken by those administrative agencies, as well as by the governors and secretaries of the states, and various courts thereof before and after the election under those same statutes, and such regulations, did not comport with those said federal constitutional provisions. That is a conflict, and it is our dispute in these defendant states, a pure question of federal, not state, law, which violations were not just against the laws of those states, but also those same violations were violations of the federal Constitution itself, as explained herein, and in the pleadings filed by our Attorney General. We find that the Court of Appeals has confused two distinct issues, that of the sufficiency of the indictment to allege a final prior felony conviction, and the sufficiency of the evidence to show that the felony conviction became final before the commission of the primary offense, So too, we the people of Texas also find that this court's majority has somehow confused the meaning itself of standing, and the injury component to state a colorable claim of a judicially cognizable interest. Specifically, this court will please recall that in Steel Company v. Citizens for a Better Environment, 523 U.S. 83, 1998, this court squarely held, because none of the relief sought would likely remedy respondent's alleged injury in fact, respondent lacks standing to maintain this suit, and this court, and the lower courts lack jurisdiction to entertain it. Pages 88-110. Here we, the people, take the position that standing cannot, and does not mean what was said and held in Steel, Supra, and in other cases, in our own case because of the court's action here, yet standing in this Texas case at bar has been made now to mean this. Because Texas has not demonstrated a judicially cognizable interest, in the manner in which another state conducts its election, he state of Texas's motion for leave to file a bill of complaint is denied for lack of standing under Article 3 of the United States Constitution. We pause here to also note for the majority that there is no difference in the standing conferred by the statutory provision found in Title 28 U.S.C. subsections 1251 A and B 3, and under Article 3, Supra. In Texas Association of Business v. Texas Air Control BD, 852 SW2D 440, Texas 1993, the Supreme Court of Texas correctly declared the law, as it relates to standing, as follows. 1. Standing. Before we reach the merits of this case, we first consider the matter of the trial court's jurisdiction, as well as our own. Specifically, we determine whether TAB has standing to challenge the statutes and regulations in question. Because TAB's standing to bring this action is not readily apparent, and because our jurisdiction, as well as that of the trial court, depends on this issue, we requested supplemental briefing on standing at the oral argument of this case. In response, the parties insist that any question of standing has been waived in the trial court, and cannot be raised by the court for the first time on appeal. We disagree. Subject matter jurisdiction is essential to the authority of a court to decide a case. Standing is implicit in the concept of subject matter jurisdiction. The standing requirement stems from two limitations on subject matter jurisdiction, the separation of powers doctrine, and, in Texas, the open courts provision. Subject matter jurisdiction is never presumed and cannot be waived. 5.
Okay, where are we now? Continue.
5. Justice Doggett confuses subject matter jurisdiction with personal jurisdiction. Only the latter can be waived when uncontested. See Texas Rules of Civil Procedure 120A. 1 limit on a court's jurisdiction under both the state and federal constitutions is the separation of powers doctrine. CTEX. Const. Art. 11. Section 1. Valley Forge Christian College vs. Americans United for Separation of Church and State, 454 U.S. 464, 471-74, 70 L, edition 2D 700, 102 S, CT 752, 1982, Worth vs. Selden, 422 U.S. 490, 498, 45 L, edition 2D 343, 95 S, CT 2197, 1974. See also, Antoine Scalia, The Doctrine of Standing as an Essential Element of the Separation of Powers, 18 Suffolk U. L. Rev. 881, 889, N.69, 1983, noting that the dicta of Flast versus Cohen, 392 U.S. 83, 100, 20 L, ed. 2d 947, 88s, ct 1942. 1968, suggesting that standing is unrelated to the separation of powers doctrine has since been disavowed. Under this doctrine, governmental authority vested in one department of government cannot be exercised by another department unless expressly permitted by the Constitution. Thus we have construed our separation of powers article to prohibit courts from issuing advisory opinions, because such is the function of the executive rather than the judicial department. 6 Fireman's INS Company v. Birch, 442 S. W. 2D 331, 333, Texas 1969, Merrow v. Corbin, 122 Texas 553, 62 SW 2D 64, 644, Texas 1933. Accordingly, we have interpreted the Uniform Declaratory Judgment Act, TEX, Civ, PRAC, and REM. Code Sections 37.001.011 to be merely a procedural device for deciding cases already within a court's jurisdiction, rather than a legislative enlargement of a court's power, permitting the rendition of advisory opinions. Fireman's INS Company, 442 SW2D at 333, United Serve. Life INS Company vs. Delaney, 396 SW2D 855, 863, Texas 1965. California Prods, Inc. vs. Puretex Lemon Juice, Inc., 160 Texas 586, 334 SW2D 780, 1960. 6. The analysis is the same under the federal Constitution. See example, Correspondence of Justices, letter from Chief Justice John J. and the Associate Justices to President George Washington, August 8, 1793 in Lawrence H. Tribe, American Constitutional Law 73 Note 3, 2nd ed. 1988. The distinctive feature of an advisory opinion is that it decides an abstract question of law without binding the parties. An opinion issued in a case brought by a party without standing is advisory, because rather than remedying an actual or imminent harm, the judgment addresses only a hypothetical injury. Texas courts, like federal courts, have no jurisdiction to render such opinions. The separation of powers doctrine is not the only constitutional basis for standing. Under federal law, standing is also an aspect of the Article 3 limitation of the judicial power to cases and controversies. Sierra Club v. Morton, 405 U.S. 727, 731, 31L, Edition 2D 636, 92S, CT 1361, 1972. To comport with Article 3, a federal court may hear a case only when the litigant has been threatened with or has sustained an injury. Valley Forge Christian College, 454 U.S. at 471. Under the Texas Constitution, standing is implicit in the Open Courts provision, which contemplates access to the courts only for those litigants suffering an injury. Specifically, the courts provision provides, all courts shall be open, and every person for an injury done him, and his land, goods, person or reputation, shall have remedy by due course of law. Texas Constitution, Article 1, Section 13, emphasis added. Because standing is a constitutional prerequisite to maintaining a suit under both federal and Texas law, we look to the more extensive jurisprudential experience of the federal courts on the subject for any guidance it may yield. Under federal law, a lack of standing deprives a court of subject matter jurisdiction, because standing is an element of such jurisdiction. Carr v. Alta Verde Industry, 931 F. 2D 1055, 1061, 5 THCIR 1991, Simmons v. Interstate Common Commission, 900 F. 2D 1023, 1026, 7th Circle 1990, MAIN v. Commissioner, Maine Department of Human Serv, 876 F.2D 1951, 1053, 1 STCIR 1989. Hassel vs. Sessions, 266 U.S. App, DC, 325, 835 F, 2D 902, 908, DCCIR 1987. We need not continue to unpack more of the doctrine of standing. Here, since Article 3, supra, in general, and Title 28 U.S.C. subsection 1251, conditionally, expressly afford Texas, and another state to sue and to be sued by each other and more states to be joined as parties, as set forth therein, there is both constitutional and statutory authority to bring suit in the Supreme Court of the United States. Finally, in the United States Court of Appeals for the Fifth Circuit, we have an appeal in which we move the Chief Circuit Judge to order our appeals not be decided there, but ordered transferred to Chief Justice Roberts to be assigned to another Federal Circuit Court of Appeals, and the motion has been ignored. Our child has been kidnapped by the deep state, and no orders and final judgment were rendered and entered of record terminating any parent-child relationship in these appeals. We in no way want the judges to hear and decide the appeals. The motion was filed and docketed. /S/Brandy Brenna Whitfield, mother of child. /S/Prophet Ronald Dwayne Whitfield, father of child. 10. Postmaster at hcdistrictclerk.com. December 13th, 2020, 2:21 p.m., 21 hours ago. Delivery has failed to these recipients or groups. c.daniel@hcdistrictclerk.com. The email address you entered couldn't be found. Please check the recipient's Last Prophet Ronald Dwayne Whitfield andicomunilavim@gmail.com. 11:06 a.m., 29 minutes ago. Reply. To me.
Okay, that ends that. As I said, I'm Prophet Ronald Dwayne Whitfield, recording here in the United States on Tuesday, 26 January 2021. I had spoken with, on last week, Friday, a clerk of the Supreme Court of the United States, and he stated to me that this document, which you just heard read, was not received by the Supreme Court of the United States. This document was mailed, correspondence was mailed from Houston, Texas, from zip code 77054, 4-digit code add-on 9998. It was deposited with the United States Postal Service, USPS, United States Postal Service, and it was received at the address of the United States Supreme Court by a person named Johnson. The United States Postal Service had given it to me. And so it shows on this document that it was received. If I can go to that page quickly.